Secret agents, now that you are viewing this message, you have chose to accept the mission. Here's the facts of the case. Landlord Carlito is insisting on bringing a friend of his, Franklin, to stay at his current tenant's house. But the issue here is that Carla does not want any strangers to stay with her. Carla brings out the contract that between her and Carlito, and Carlito brings up the fact that he's allowed unrestricted access to anyone. Carla then begins to argue that that is only for electricians, gardeners, or any handyman. Carlito then states that Carla is only a mere licensee and not a leaseholder, as she has signed only a license agreement. Now it's up to you to help Carla to advise if Carla has any rights to this matter. Please help her, secret agents. It's up to you.
Self-destruct sequence will initiate in 60 seconds. All
Hi, Chris Ty. Me and my team have been undercover in Taylor's Law School in our second year, and we've heard your case and we're here to help.
Hi, I'm your agent here. My name is Lim Suiling Kirtana.
Hi, I'm your agent. My name is Wong Kui Ying. Nice to meet you.
Hello, here is Agent Meng Zixuan.
Access code 0330026. Secret agent that reached out to you reporting for duty.
Lord Hoffman, in the case of Bruton and London and Quadrant Housing Trust, defined a lease or tenancy is a contractually binding agreement, which may and usually does create proprietary interest, called a leasehold estate, or technically term of years absolute. But whether in fact it does so will depend upon whether the landlord had an interest out of which he could grant it. Nemo cum dat quod non habet, which basically means no one gives what he does not have. The person who grants a lease is called a leaser or landlord, and the person who acquires it, the leasee or tenant. Term of use absolute is defined under Section 205 of the Law of Property Act 1925, which means a term of years taking effect either in possession or in the reversion, whether or not at a rent. In the case Street and Munford, Mr. Street granted Mrs. Munford the right to occupy 2 rooms. There were other conditions in the agreement which was labeled the license agreement. It also contained a clause that stipulated that Mrs. Mountford accepted that she was not protected by the Rent Act. However, it is not possible to contract out the Rent Act, and so the question is whether this was considered a lease or a license. Lord Templeman identified 3 crucial features for a lease: the grant of exclusive possession, for a period of time which is certain, and for the payment of rent. The most important characteristics for a lease is the requirement of exclusive possession. Without a grant of exclusive possession in the relevant land, there is no lease, only a license. In the principle, there is only an important difference between exclusive possession and exclusive occupation. In acquiring exclusive possession, the occupier is deemed to have a stake in the land, an authority to exercise the rights of the land, which is consistent with the acquisition and the legal estate conferred only by granting of a tenancy. Unlike the occupier, with the only rights of the exclusive occupation, an occupier with exclusive possession can keep out strangers and keep out the landlord, as explained by Lord Templeman in the case of Mumford and Street. The concept of exclusive possession is notoriously elusive, as it can be seen in a really confused debate over the distinction between what is a lease and what is a license. In essence, the existence of exclusive possession is a matter for the construction of the agreement between the parties in light of their conduct in relation to the property, which can be seen in the cases of Antonies and Villiers, as well as AG Securities and Vaughan. Thus, if the occupier has been granted the exclusive right to use the property, even to the exclusion of the landlord, then there is a strong presumption that the agreement amounts up to a lease. The only exceptions to this are those cases identified by Lord Templeman in the case of Street and Mumford, where because of some special circumstances, exclusive possession may exist, but a tenancy does not. An example is the service of occupancy of Norris and Checksfield, where the right to occupy was given to an employee for a better performance of his duties, and cases where the occupation is given as an act of generosity, friendship, or charity, as in the case of Gray and Taylor, where occupation of the almshouse did not indicate the existence of a lease.
Since one of the requirements of a lease is that it confers a right to exclusive possession, an obvious strategy for landlord to adopt is to insert a clause into the agreement denying exclusive possession. The law does not stop at the face of the matter. Instead, it asks whether any provisions of the agreement are shams or pretenses. There are three different types of shams that should be distinguished. First and least problematic is the situation where the terminology employed in an agreement misrepresents the legal category into which the arrangement falls. Secondly, document may include clauses by which neither party intends to be bound and which are obviously a smokescreen to cover the real intention of both contracting parties. Thirdly, where there are a number of transactions creating a composite whole, the court may look at the overall result of what is achieved rather than considering the individual transaction in isolation. The starting point for any discussion of shams transaction must be the decision in Snook and London and West Riding Investment Limited, where Lord Diplock defined sham is a term intended by the parties to give to third parties or to the court the appearance of creating between the parties' legal rights and obligation different from the actual legal rights and obligation, if any, which the party intend to create. In Aslan and Murphy, Lord Donaldson, Master of the Row, held that the court should consider whether the whole agreement was a sham, and if it was not, whether in the light of the factual situation, the provision were part of the true bargains between the parties or mere pretenses. In Antodius and Villas, a one-bedroom flat was let to a young unmarried but cohabiting couples under separate but identical license agreements executed simultaneously. It was stipulated that the couple were not to have exclusive possession. The court found it to be a lease. The agreements were interdependent and were to be read as constituting a single transaction. The fact that the couple intended to occupy the flat as man and wife, an intention known to the lessor, created a joint tenancy, and the purported retention by the lessor of the right to share or introduce others to share the limited accommodation was clearly a pretense aimed at depriving the couple of Rent Act protection. In contrast, in AG Security and Wolfgang, concerned a 4-bedroom flat led to 4 individual flat sharers, each of whom enter into a separate short-term license agreement. Such agreements being made at different times on different terms with different rents. All the agreements provided that each occupant had the right to use the flat in common with others who have or may from time to time be granted the like right but without the right to exclusive possession of any part of the flat. The court found them to be licensed, as each occupant has exclusive possession of one room only, which is their own bedroom, the rest of the accommodation being shared. Therefore, they did not enjoy between themselves a collective joint tenancy. Back to the issue in the question. Although the written agreement contained the terms of unrestricted access, and the landlord labelled the agreement that was signed between the both parties a license agreement, it is the court's duty to be prepared to see through any written document purporting to impose onerous obligations which are out of step with what the parties clearly must have intended. If the term is considered as a sham, then the agreement will likely be a lease. If not, the agreement will be considered as a license.
The second requirement is that there must be rent. Rent may be paid either every week, month, or year for the occupation of the premises. Under Section 205 of the Law Property Act 1925, tenancies such as those within the Rent Acts must be supported by rents to qualify for statutory protection. In Street and Mumford, Lord Templeman mentioned that the assistance of the rent can imply the words of deed in the absence of an express promise by the tenant. However, in the case of Ashburn, Anstead, and Arnott, it was held that rent is not essential to the existence of a lease where the parties to a transaction have intended to be legally bound by the relationship of landlord and tenant but have not specified the payment of rent. However, the rent is not necessary to be in monetary terms but have a certain monetary value. It can be in good service or payable in kind. The only clear requirement is that the amount of rent must be capable of being rendered certain. Thus, in Bostock and Bryant, the obligation to pay fluctuating utility bills could not be regarded as rent, being an uncertain sum. Last but not least, a lease of tenancy must be for a fixed term of years absolute. This means not only that the lease must exist for a clearly defined period of time, but also the term rented must be certain. The lease must be of certain maximum duration and the commencement of the lease. Any lease, or rather any intended lease that fails to satisfy this condition is necessarily void because it does not amount to a term and it will fail for uncertainty. In the judgment of Lord Green, Master of Rolls in Lace and Chandler, it was mentioned that a term created by a leasehold tenancy agreement must be expressed either with certainty and specifically, or to be looked as a certain estimate of what the term is meant to be at the time when the lease takes effect. Therefore, the lease for the duration of the Second World War was held void as being of uncertain maximum duration. It was reaffirmed in the case of Prudential Assurance and London Residuary by House of Lords that a leasehold term must be certain from the outset. Besides a fixed-term lease, there is a periodic tenancy. In this instance, after a fixed-term period has come to an end, the tenant continues to retain rights of exclusive possession over the property indefinitely. In Hammersmith and Fulham London Borough Council and Monk, the court has recognized periodic tenancies as a continuing and subsisting active agreement between the parties that they wish to remain in a leasehold relationship. Therefore, for tenants to show that they have the lease but not just simply a license, they must show that they have acquired a right to exclusive possession of land for a certain period of time, and they must be rent.
After talking about requirement of lease, let's move on to legal and equitable lease. In order to create a legal lease, the following rules laid down by statute should be followed. Firstly, according to Section 52, subsection 2d and 54, subsection 2 of the Law of Property Act 1925, leases for not over 3 years grant the tenant an immediate right to possession of land without payment of an initial sum, whether made orally, by written contract, or by deed. Secondly, Section 52, subsection 1 of this Act regulate that leases are required to be created by deed to have any prospect of taking effect as a legal estate. If leases for more than 3 years, of 3 years or less, fail to fall within the first category mentioned. For example, in Cargill and Julian, it was held that an intent assignment of tenancy which not have been completed in writing by deed was ineffective and as against the landlord. Thirdly, the lease must be registered as a title at Ham Land Registry if it is granted by deed out of registered land and for a term more than 7 years as mentioned under Section 27, subsection 2 of the Land Registration Act 2002. Section 27, subsection 1 states that failure to register amounts to the equitable estate. Finally, Section 4, subsection 1 of the Land Registry Act 2002 illustrates that the lease must also be registered as a title at Ham Land Registry if it is granted by deed out of unregistered land and for a term over 7 years. Similarly, according to Section 7, failure to register means the lease would only be registered as an equitable estate. When talk about equitable lease, Section 2 of the Law of Property Act 1989 come into force, which illustrates the contracts for sale of land to be made by signed writing. Section 1 states a contract for the sale or other disposition of an interest in land can only be made in writing and only by incorporating all the terms which the parties have expressly agreed in one document or where contracts are exchanged in each. Section 2 is the terms may be incorporated in a document, neither by stating out in it or by reference to some other document. And Section 3 states the documents incorporating the terms or where contracts are exchanged. One of the documents incorporating them, but not necessarily the same one, must be signed by or on behalf of each party to the contract. In Welsh and Lansdale, it established that an agreement for a lease is to be treated as an equitable lease if the agreement is capable of specific performance. Now, I will talk about the registered land and unregistered land. In registered land, equitable lease can be entered on the register of title of land through a notice under Section 34 of the Land Registry Act 2002. According to Section 28 and 29, such leases are protected by registration and are effective against later transfers of the reversion. Nevertheless, even if not registered in this way, such lease will take effect as interest that overrides transfer risk. In unregistered land, equitable leases are registrable as Class C4 land charges. Failure to do so would render the estate contract void against the purchaser for value.
Licenses per se or mere licenses cannot bind third parties. They are merely personal rights. They apply only to the parties to the license, in this case, the licensor and the licensee. Neither the benefit nor the burden of the license can be transferred to another person. However, a license by estoppel is capable of binding third parties, and if it relates to land, can be a property right. A license is a permission given by the occupier of the land to another, so the licensor to the licensee, to do something on the land which without the permission would otherwise be a trespass. The licensee does not have to have any interest in any other land. In the case of Thomas and Sorrell, judges held a license properly passeth no interest, nor alters or transfers property in anything, but only makes an action lawful, which without it had been unlawful. There are four main classes of licenses: bare, contractual, coupled with an interest, and licensed by estoppel. The last one not really being of any relevance to the scenario given. Bare licenses are granted for no consideration from the licensee for the permission. They may be expressed, for example, permission to hold a pop concert on a field, or implied, such as permission for the postman to deliver your mail to your house. A bare license terminates upon the licensor requesting the licensee to cease the previously permitted act, for example, by asking an invitee to leave. That is, they can be revoked by the licensor at will. Case on point, Wood and Leadbitter. Contractual licenses are granted for consideration. For instance, a license to enter a cinema and watch the film upon purchase of a ticket. This would be a very short license, but otherwise last longer. A member of, say, a golf club, having paid his annual subscription, has a license during that period to enjoy the facilities and enter the premise at any time.
So, as a conclusion, the issue arises as to whether Carla has a lease of property or the agreement between she and Carlito is a Maryland license.
If Carla had fulfilled the three requirements of lease that is mentioned in the case of Street and Mumford, that she must have the exclusive possession of the house for a certain period of time and at a rent. The agreement between the parties will then be a lease, but not just simply a license agreement.
Therefore, the term unrestricted access that was mentioned in the agreement will likely be void, and Carlito is prohibited from allowing his friend onto the premises to occupy one of the rooms, since Carla would likely be the tenant who has exclusive possession over the land.
On the other hand, If the requirement listed in Street and Mountford is not fulfilled, then Carla will only acquire a license over the land.
Finally, with all that said, the landlord would be able to enter the house without the permission and can revoke your license with a residual notice. Thank you. Agent signing out.